So hello guys, what's up and welcome back to my YouTube channel. It's me, your girl Barrister Neze, and this is Nezeville. Despite many countries all around the world are expunging the capital punishment, the death penalty, from their laws and fast replacing it with life imprisonment, some other countries have insisted that there are some offenses that a jail term will not suffice, especially grievous offenses which have led to the loss of a life. Nigeria, for example, is one that practices the death penalty. Offenses such as murder, armed robbery, kidnapping, treason, which is of course trying to overthrow a sitting government, aiding the suicide of a minor, perjury in a capital offense leading to the execution of somebody. That is when you come to court to give a false testimony and it was upon your testimony that somebody got the death penalty and was executed. Such a perjury is also punishable by death. Okay? And for northern Nigeria, which is governed by a totally different criminal law system, the Sharia law, offenses such as rape, blasphemy, adultery, homosexuality, and witchcraft are also punishable by death under the penal code. And as for military offenses, mutiny of course still attracts the capital punishment in Nigeria. So yes, there are a truckload of offenses that still attract the capital punishment here in Nigeria. Only a few days ago, we got wind of the tragic story of Timothy Adeguke, the young MBA student of Obafemi Awolowo University in Ife. A husband and a father who came all the way from Abuja to Ife to take his final examinations and lodged in a hotel and was eventually eliminated by the owner of that hotel, Dr. Rahmon, in connivance with his son and some other members of his staff. The case has been in court for about 2-3 years now, and only last week, the trial judge pronounced a sentence of death by hanging for Dr. Rahmon along with 2 other members of his staff. So I'm going to leave a link to the detailed video I did about that story down in the description box, so if you haven't watched it, you can go catch up on it. So it became very necessary for me to do this follow-up video because of the engagement, the comments that I got in that last video. And of course, you guys know that here on Nezeville, I don't just bring to you guys half-baked information. I give you the full detailed reports. So you would not only benefit from that content, but you go home with a wide range of knowledge that would help you in other situations. Yes, that is what we do on Nezeville. So yes, Dr. Rahmon has been sentenced to die, but a lot of people are oblivious of how the legal system actually works. Many people are of the opinion that what's to happen next is that in the next couple of days or weeks, Dr. Rahmon will be taken away from his prison cell, taken straight to the hangman, gets executed, and that will be the end of it. But no, it is very, very, very far from that. A whole lot of things could still happen in this case. So in today's video, guys, I will be enlightening us on what the law says about the very many things that could happen to actually stop a death sentence from being implemented. 1. An appeal. An appeal in layman definition is simply contesting the decision of a lower court before a higher or superior court, seeking that higher court to quash or modify or reduce the judgment of that lower court. So during an appeal, the trial is held afresh and the appeal court will revisit the whole facts of the case, after which it could arrive at a totally different decision from the lower court. So Dr. Rahmon's trial took place in a high court, and that avails him 2 other levels of appeal. He can first direct his appeal to the Court of Appeal, and if the Court of Appeal upholds the pronouncements of the High Court insisting that the death penalty must hold, he still has a right to a second level of appeal at the Supreme Court. And in law, nobody has the right to carry out a death sentence without first allowing an accused person, a convicted person, fully exhaust his rights of appeal up to the highest levels if he chooses to. It is only when the levels of appeals have been exhausted and the Supreme Court upholds the decision, only then can that convicted person be executed, except the convicted person have waived his right to an appeal and have decided to accept the decision of the lower courts, which most times is very unlikely, especially when it comes to the death sentence. During an appeal, 4 things can happen. First, the Superior Court can choose to uphold, to confirm the lower court's decision by saying, Oga, you did it though. You did that crime. We have reviewed the case, we have tried it all over again, and we have arrived at that same decision. So go and serve your sentence. That is the first thing that can happen, upholding the sentence. 2, the appellate court can choose to reduce the sentence, so it can even choose to modify the charges. For example, if someone is charged with murder, the appeal court can review the facts of the case and say, no, this is not premeditated murder. This is manslaughter. This is death caused by mistake. He or she didn't plan to eliminate that person. So the appeal court can reduce the offense and reduce the punishment. So in other words, a murder case which got a death sentence can be reduced to a manslaughter case with a life imprisonment sentence. That is the second thing the appellate court can do, reduce sentence. The third thing that an appeal court can do is to completely, totally quash the decision of the lower courts, thereby discharging and acquitting the accused person. So after reviewing the facts of the case, the appellate court can say this person was charged erroneously. Mr. Rahmon was not in the hotel. The prosecution didn't prove that he was the one that gave them the orders to carry out the murder. So just because of that murder happened in his premises, he shouldn't be automatically sentenced to death. So they can choose to quash that decision entirely and acquit and discharge Dr. Rahmon. That is a possibility in all criminal trials. The fourth thing that an appellate court can do is to quash the decision and order a retrial. The first one is to quash and discharge and acquit. This fourth one is to quash and order a retrial. This time, not because the verdict was bad or wrong, but because the process at which the verdict was reached was flawed. In other words, due to technicality. Now, the law is not flexible with some requirements when it comes to a trial. For example, taking a plea. The law has made it compulsory that for any criminal trial to stand, that accused person must be docked, enter the dock, and the offenses must be read to him, every single offense, and he must choose to either plead guilty or not guilty. So for example, if that person was not informed of the offense that he or she is being charged for, or maybe the person was convicted on 4 offenses, but it was only 3 that was read out to him, even though he was the one that committed that offense, that judgment is flawed on technical grounds. And there are so many other reasons why a judgment can be put aside on technical grounds. And most times in this case, the appellate court would direct that lower court to reinstitute the trial and hold it afresh. That is a possibility also. So nobody is executing Dr. Rahmon right away. Sorry if that makes you upset, but that is the truth and that is the law. And we can better limb that Dr. Rahmon, with all his exposure, education and connection, will not just go down without a fight. No, I'm certain that he will appeal the judgment. And these processes, my dear brothers and sisters, can take a very lengthy time to conclude. I'm talking about going from the magistrate court or the high court to the court of appeal and then the Supreme Court. It takes a long time. It can stretch from 5, 10, 15 or even 20 years before a final resolution is reached. So we are watching, hoping and praying that justice will also be served at these superior courts. Trust me to keep you updated if anything comes up. The second thing that can happen to stop or halt or delay an execution either of Dr. Rahmon or any other person on death row is the governor's refusal to sign the death warrant. When a death sentence is passed, and even if that verdict has been upheld by all the appellate courts in the world, that sentence can still not be executed without the governor's consent. The governor of that state where the sentence was given must, as a matter of law, sign the death warrant before that execution can take place. It might be shocking if I informed you that since 1999, when Nigeria returned to civilian rule, only 2 governors have signed the death warrant. The former governor of Edo State, Governor Adams Oshiomhole, and former Governor Danjide of Kano State. In fact, after 2006, no executions took place in Nigeria until 2013. That's more than 7 years after. Despite thousands of condemned prisoners were awaiting execution. As we speak presently, there are almost 4,000 condemned felons in the prisons awaiting execution, but the governors have refused to sign their death warrants. It is uncertain why governors constantly shy away from signing these warrants, but I strongly suspect that it might be due to moral or religious reasons. You know, that African thing of Abego, I don't want this number of people's blood to be on my head. Let the next government take care of it. Me, I'm not signing for over 1,000 or 500 people to just be killed. I don't want that kind of base on my generation or on my family. Could be that. Another reason why that may be the case is because these governors might also understand that due to, the society we find ourselves in, poor indigent people who do not have the resources or the people to fight for them to help them get justice might be condemned wrongly and sentenced to death. So some governors shy away from signing the death warrant because they do not want to be the reason why an innocent person was executed. And it has happened severally in the past, where after execution, new facts come up to prove that someone who has been killed is actually innocent of a crime. So that might be another reason why governors in Nigeria are very, very reluctant to sign the thousands of death warrants awaiting them. So yes, governors in Nigeria hardly or never ever sign the death warrants, thereby commuting these people to a lifetime of uncertainty, or should we say, automatically giving them the life imprisonment. So many high-profile cases and high-profile criminals are still, as at today, languishing in prison, awaiting their execution. Number 3, a pardon or an executive order. The third reason why Dr. Rahman or any other convicted person awaiting the hangman's noose may not be executed is due to governor's pardon or what can be termed as an executive order. A governor of a state is by law charged with the right, with the liberty to pardon any offense regardless of its severity. The state governor can pardon the offense if it's a state offense, and the President of the Federal Republic can pardon the offense if it is a federal offense like a treason. Only in January of this year, Governor Akeredolu, the governor of Ondo State, granted state pardon to 7 convicts who were awaiting execution. In March of this year alone, Governor Ganduje granted pardon in a similar fashion to 12 prisoners on death row. And not so long ago again, the governor of Lagos State, Governor Babajide Sanwo-Olu, signed some executive orders commuting some death penalties for 3 persons and reducing it to life imprisonment. So you can see that governors are even more often pardoning these convicted people to even signing their death warrants. So it's even more likely, the numbers, the statistics are more in favor of a pardon than signing of the death warrant. But this is very different from the first one. This is very different from the governor's refusal to sign the warrant, because when the governor refuses to sign the warrant, it doesn't exculpate, it doesn't neutralize, it doesn't change the fact that that person will still be in prison and still have that conviction hung on his neck. Okay, it's just that the person will be living indefinitely in prison custody awaiting execution. But this case is very different, because when you get a governor's pardon, it is tantamount to the fact that your sins are forgiven. You are free to live, free as a bird. Or in another case, the governor can choose to reduce that sentence. Instead of execution, the governor can choose to substitute it with a jail term. It is the law. A governor is a governor, and it is the governor's prerogative to exercise without explanation. So this also is a possibility. Lastly, and although it may not directly relate to the case at hand, it's also good I chip it in for information and knowledge purposes that the law is prohibited from executing children, minors who have committed capital offenses, as well as pregnant women. So when a sentence is about to be passed and it is knowledge that that woman is pregnant, the judge cannot sentence a pregnant woman to death. Her punishment will be reduced to life imprisonment, even if that offense would normally attract the death penalty. So this is it, guys. It is not as straightforward. It is not as plug and play as you wish, or as you think, or as you will expect. A whole lot can still happen. So let us keep our fingers crossed and hope that justice at the end of the day, regardless of how long it takes, will still be given. I do hope you have learned a thing or two from this informative, knowledge-packed, resourceful video. Okay, if you have, don't keep the knowledge to yourself alone. Do share this video to everybody and anybody that you think will benefit from this knowledge. And if you're not subscribed, why are you shortchanging yourself? Do hit the subscribe button. Do give this video a big thumbs up. Drop all your comments, your fears, your suspicion, your thoughts. Drop all of them down in the comment section. Turn on your bell notifications and stay glued, because we have so much more coming your way. It's me, your girl, Barrister Neze, and this is Nezeville. I'll see you guys in my next one. For now, bye.